the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Hello, everyone, and welcome to the Fair Housing Insiders Case Files, the show where we explore real fair housing cases to help all of you, all of us, property management professionals. We want to stay informed, and these case files, help us avoid mistakes. So we're looking forward to today's discussion. My name is Jonathan Saar, and today we're focusing on a series of events involving Aon Management and several affiliated property owners, and the issue whether denying assigned parking spaces for residents with disabilities violates the Fair Housing Act. Joining us to break it down today is attorney Leslie Tucker. Leslie, welcome.
Thanks, Jonathan. Glad to be here.
So can you give us a bit of an overview of what led to this case?
Sure. Yes, of course. So in 2020, 3 nonprofit fair housing organizations conducted a bunch of tests, fair housing tests, at multiple properties managed by Aon Management in Pennsylvania and Delaware. The testing was designed to evaluate how this company and how these properties responded to requests for assigned parking from individuals with mobility impairments. According to this complaint, the results of the testing showed that at each of the sites, the leasing agents informed the testers that parking was only on a first-come, first-served basis, and that reserved parking was not offered, even when it was requested.
Interesting. So, testing at different sites. So what were the responses like? Were they similar at each site?
Yeah, that's what the complaint says. So at all 7 tested properties, leasing staff allegedly responded in a very consistent manner. Mm-hmm. The tests were conducted in person, over the phone, and via email. And when the testers disclosed that either they or a family member had a disability and they asked for a reserved parking space, the staff stated that parking could not be reserved and was only available on a first-come, first-served basis. In some cases, the staff mentioned the use of accessible or handicap spaces, but emphasized that they couldn't be assigned to anyone specific.
Intriguing. So did any of the sites suggest alternatives?
Well, in some instances, staff explained that tenants could request accessible parking through the local Department of Motor Vehicles, which again would permit them to park in accessible spaces. There was also an option provided for renting a parking space in a parking garage for a fee. However, the plaintiffs alleged that none of these responses included a willingness to consider, a direct assignment of parking as a reasonable accommodation.
Okay. Yeah, very interesting case. So let's dig a little bit deeper into some of the legal developments that came with this. What happened after the investigation was concluded?
So following the testing, which happened all throughout 2020, the 3 fair housing organizations filed a joint HUD complaint. The complaint alleged that this management company and all the owners of these properties engaged in discriminatory housing practices by refusing to grant reasonable accommodations. HUD then conducted its own investigation, which is what it does when complaints are filed. Mm-hmm. And based on the evidence gathered in that investigation, they did issue a charge of discrimination in 2023. That charge stated that there was reasonable cause to believe that there had been a violation. And those violations were failing to provide reasonable accommodations, making housing unavailable because of disability, and making statements that indicated limitations or preference based on disability. So the respondents, who are the management company and the owners, chose to move the matter to federal court, which is permitted under the Fair Housing Act, And then the Department of Justice subsequently filed this case in the summer of 2023. The fair housing groups, this happens, but is not something that happens every time, in that the fair housing groups that did the testing filed a motion to intervene in this case, which allows them to become parties to the lawsuit. So essentially, the Department of Justice, the government, is the plaintiff in this lawsuit, but now they have filed this motion to also become parties, which gives them the right to seek their own damages. And those damages are requested basically because they spent time, money on the testing. That's generally referred to as diversion of resources.
Got it. Wow. That makes it even bigger. that's more involved.
Yeah.
So this wasn't just about righting a wrong for just one person. It was a coordinated enforcement effort, right?
Absolutely. Yeah. So it involved multiple organizations in multiple states working together over a 12-month period of time to dig into what they believe to be a pattern of behavior across a bunch of different properties. So that's part of why this case is significant. It wasn't just a single incident or a single statement. It was an alleged systemic policy at multiple properties under the same management structure.
Okay. Well, I know our audience is riveted to this. There's a lot of implications for property managers. So what can our community learn from this case?
So there are a couple of important takeaways, I think. First and foremost, housing providers need to understand that the FHA, the Fair Housing Act, requires more than just equal treatment. It requires equitable treatment. And that means that sometimes you have to make exceptions to your normal policies when it comes to people with disabilities. Okay, that's what reasonable accommodations are all about.
Right.
And a policy of, we just don't assign parking to anyone may seem neutral on its face because it applies to everyone. But when a person with a mobility impairment requests a reserved parking space and is denied because of that blanket policy, it can become discriminatory under federal law. And secondly, the case demonstrates that staff really need to be trained. Leasing agents are, often the very first point of contact. They are the people that greet prospects and answer phones, and their responses to questions for accommodations matter. They can get you in trouble. If they immediately say no without asking any questions, explaining your accommodation process, or at the very least directing that request to someone else, that could open the company up to liability.
Okay. Thank you for the explanation. I know our community appreciates that level of insight. So what does that process look like when it's done correctly?
So your accommodation process needs to be very clear for how people review, how they receive, how they respond. And that generally involves providing a very simple way for people to make requests, either verbally or in writing, how you evaluate those requests based on the person's needs, a process for engaging in the interactive process, meaning there is some sort of back and forth dialogue about what the person needs, why they need it, what you can provide, and of course, documenting that entire process. Please note that nothing in what I just said includes providing a quick verbal response to an accommodation request. Okay, that's really important. So, housing providers don't have to grant a request if it would be a financial or an administrative burden. It alters the nature of your program. But to be clear, the burden of proof is on you, is on the housing provider to demonstrate that if you do deny a request, which is allegedly what happened in all of these cases, that your denial was justified. And simply just saying, we don't do that here, that's just not an adequate response.
Yeah. And very good. Thank you, Leslie. That's very helpful. So even if a provider ultimately can't meet the request, how they respond still matters?
Definitely. Absolutely. So the law requires that the request has to be considered in all instances. Dismissing a request out of hand, especially without documentation or any review, could lead to claims of discrimination, like it did here. But even if the denial was otherwise valid. So proper training, thoughtful procedures help avoid compliance issues.
Very nice. Yeah. Thank you so much. Excellent overview. I know our audience really appreciate it. So thank you everyone for tuning in today. Appreciate your supporting this channel and all the content that we provide. This case serves as a really good example of how day-to-day policies like parking rules need to be adaptable when we're talking about disability accommodations. If your team hasn't reviewed your accommodation procedures recently, now is a good time. Use this as a training video for your team and see where you measure up. Make sure your staff understands their responsibilities under the Fair Housing Act and knows how to respond appropriately to accommodation requests. And that's it for today, for today's episode of Case Files. Stay informed, stay fair, and we will see you next time. Take care, everyone.